Chris Hipkins.
Thank you very much, Mr Chair. Mr Chair, I've got a number of points I want to raise, but first I'd like to raise an issue around interpretation that the Minister might be able to help me with, and it might be my misunderstanding of the way the bill's been drafted and some of the drafting changes that have been made to it. And if he wants to interrupt me, I'll happily yield some of my time for him to do so. But the first clause of the Schedule 1, which talks about interpretation, there have been changes made since the bill was originally drafted to remove the definition of 2013 Act and Principal Act and simply say now, and in this schedule, the 2013 Act means the Employment Relations Amendment Act 2013. Now, if we then move, and I'll pick a clause, say clause 2(6), I think potentially the drafting changes have made this incredibly confusing, because if you look at subclause 6, it now says Part 6A of this Act, which I assume means this Act that we are now debating, as it was immediately before the commencement of the 2013 Act, i.e. this Act that we are now debating, continues to apply to the restructuring as if the 2013 Act, i.e. this Act, had not been passed. So the question that I have is, how can this Act not apply to this Act if it hasn't been passed? It seems to me that in the changes to the drafting, we've actually created quite a circular situation. You may as well remove the clause altogether potentially, because it seems to be a double negative or some other issue around interpretation, because previously it said that the Principal Act would continue to apply effectively as if this Act had not been passed. But because of the changes to the definitions, we now seem to be in this situation where that clause no longer makes any sense. And if we look at the remainder of the schedule, and I'm happy for the Minister to explain, I may have got that wrong or I might be right, and I'm happy for him to explain, because it seems to me that there are these clauses all the rest of the way through this particular schedule, and if my interpretation of it is incorrect, then he may be able to clear that up, because the rest of the schedule, and I think the second schedule as well, doesn't seem to make any sense. I'm happy to allow him to take the floor, and I'll come back to the rest of my comments if that would be useful, or I could just then continue on with the rest of my comments. So the question, the second question that I have for the Minister, and I hope that he will answer this, and again it comes back to issues of interpretation around whether I suspect the intention of this clause, or some of these clauses here, and again I'm on subpart 5 and 6 at the moment, or part 6 actually, which relates to, particularly to the vulnerable workers. Part 6A of the Act relates to the vulnerable workers. And I suspect that the intention of this clause, and again the Minister could correct me if I'm wrong, is to ensure that where the restructuring has commenced prior to the passing of the passage of this particular piece of legislation, those workers affected by that restructuring that's already commenced would continue to enjoy the same protections they would have had prior. So my interpretation of it is that this is specifically designed to ensure that that particular part of the Act is not applied retrospectively. Now, the questions around interpretation I have of that is how you would deem whether the commencement point for a restructuring. For example, in the contracting out environment, and Part 6A is often, primarily I would suspect relates to contracting out environments. If a contract has been put out for tender, for example, but not let at the point that this Act is passed, would that provision apply? So, of course, often the restructuring occurs actually after the contract has been awarded, but the mere putting out to tender of the contract really from the employee's perspective is the point at which the uncertainty and the vulnerability really starts to kick in. So are we looking at this from the perspective of the employer who doesn't get the answer until they know whether or not they've been awarded the contract, or the employee whose job is put under question the minute that the contract that they're subject to is put out for tender, because the whole purpose of this particular provision is around providing additional certainty to employees in that vulnerable situation, whether they be catering contractors or cleaning contractors or whatever. So to put a practical context around it, if I could illustrate it by way of example, if a firm that currently contracts with one cleaning company to provide cleaning of their offices, and it has fewer than the number of staff that are now that are covered by the exemption, has fewer than that number of staff employed within it, Mr Chair. I'm just waiting for the bell to ring. I can see you reaching forward, Mr Chair.
Mr Hipkins.
Thank you. And it has fewer than the number of staff covered by, therefore means that it would be covered by the exemption. That contract's put out to tender. Those staff continue to do their jobs in the intervening period while the contract is put out to tender. A new contract is awarded to a different company, and at that point, of course, the restructuring is well and truly underway. But from the staff's perspective, once they know the contract's being put out to tender in this cleaning company, they know, and for example, it could even be that the company who currently does the cleaning contract doesn't even apply. They might not even be tendering, but they might continue to do the work until the tender has been let. Now, to all intents and purposes for those staff members concerned, the uncertainty is there, the restructuring has begun, they know that there's a new contract, they don't know whether they're going to be required by the new contractor. Under the Act as it currently exists, my understanding is that they would be protected and they would be covered under the current Act. Would that continue to apply to them once this amendment has been passed? Because it would seem to me that this particular clause in the first schedule, subclause, was it clause 2, subclause 6, is intended to ensure that if the restructuring was already underway, that the exemptions that the bill puts in place wouldn't be applied retrospectively. So I think that particular point of clarification would be a very useful one. So I think those are probably the two issues of interpretation that I would like further clarification on, because again, just to come back to my first one around the interpretation section, this Act is referred to all the way through, and the striking out happens in clause 2.2, clause 2.3, clause 2.4, 2.5, basically all the way through, and it seems to me that, unless I've got it entirely wrong, and the Minister indicated that he thought I might have, and I look forward to his detailed explanation of how I might have that wrong. It seems to me that we've got a bunch of double negatives in here that makes the schedules particularly or potentially seem quite redundant and certainly don't seem to make any sense. So if he could deal with that, that would be good. Schedule 2 makes consequential amendments to the State Sector Act and to the Wages Protection Act. It makes changes around strikes within the state sector and the provisions around strike within the state sector. And then there's further changes to the wages, minor changes to the what appear to be minor changes to the Wages Protection Act. So I think I'll leave my comments at that. I look forward to the Minister's clarification of those 2 points if he is able to do that for us.
Mr Chair. The Honourable Minister.
Thank you, Mr Chairman. I appreciate the Honourable Member's intervention and some very good technical questions around the